Hi, thanks for using my court coach. I'm Sarah. I'll be your instructor today as we talk about the Form Interrogatories form for family law, also known as Form FL-145. As with all our court forms, you want to start off by filling in your identifying case caption information at the top. Below that, you're going to list who the asking party is, that would be you, who the answering party is, that's the party this form is getting served upon, as well as the set number. If this is the first time you are serving this form on the other side, that would be set number 1. This is a form that does not get filed with the court. It just gets served directly on the other side. There are some instructions for both parties, basically just stating that if you do have a privilege that you want to communicate and provide as your explanation for not providing a certain or responding to a certain interrogatory, you may claim a privilege. And privileges, again, are confidential communications such as attorney-client privilege, or if it's medical records or medical information that's being requested, those are all common privileges. Below that, this form defines or provides certain definitions for some of the terms that are going to be used on the next page to the opposing party, and provides them with instructions on how to respond. Section 3 does say that on the next page, you need to check the box for each interrogatory you want to propound, and we will go through those in further detail. And then finally, at the bottom, this is telling the opposing party that this needs to be signed under penalty of perjury. And so when they submit their written statement to you or the written response to you in response to these interrogatories, they need to sign, date, and state that the responses are being provided under penalty of perjury. The next sheet has the actual interrogatories. Again, you're going to check the box next to each interrogatory that you want the other side to answer. The first one is just general personal history, where they state their full name, current residence address, work address, social security number, any other names they've used, and the dates that they use those names during. The next interrogatory is asking about agreements, if there are any agreements between the two parties regarding disposition of assets, debts, or support. More than likely, if this is just a paternity case or it's not a dissolution of marriage or legal separation, you probably would not inquire into this, but that is up to you. The next section asks if there's any legal actions that the other party is involved in or anticipates being involved in. Below that, you would mark if you want the other party to list the name, age, and relationship to them of every person at their present address. Below that, if the other party is providing support to others, you can have them identify those people that they're providing support to and the amount of support being paid. Below that, item 6 is support received for others. If the other side is receiving any support from others, then you would have them, you would mark this box to have them identify who is supporting them financially. The next box is current income. You would check this box if you want the other party to list the income they've received for the last 12 months, its source, the basis for contribution, and the total amount received from each source, as well as provide their last 3 paycheck stubs. This is a very important one whenever support is at issue. Likewise, number 8, if support is at issue or any other finances, you would want to mark this box to ask them to provide information related to any other source of income that was not previously disclosed above. Item number 9, mark this box if you would like them to be ordered to produce copies of their tax returns from the last 3 years. Item 10, if you want them to fill out a schedule of assets and debts, that's the Form FL-142, mark this box and attach a blank schedule of assets and debts to this form. Number 11 has to do separate property contentions. Again, you'd probably only mark this box if you are in the middle of a divorce or legal separation. This would have the other party disclose what they believe to be their separate property and why. Item number 12, property valuations. If you want to know if the other party has received any written offers to purchase or have had written appraisals of any of their assets that are listed on the completed schedule of assets and debts, you would mark box 12. Item 13, if you want the other party to disclose if they have any property that is currently being held by a third party, you would mark box 13. Item 14, if you mark this box, the other side needs to disclose their retirement and other benefits and identify each plan and administrator and custodian of records. Item 15, 16, again, these are two that are related more likely to a divorce or legal separation case. But 15, if you mark this box, the other side would have to state any legal right to be reimbursed for expenditures of their separate or community property that they believe they have. In item 16, they would have to list any reimbursement credits they believe they're due for payments of community debt since the date of separation. Item 17, if you want the other party to disclose any insurance benefits that currently cover them or their children or assets, you'd mark box 17, and this applies to health, life, automobile, and disability insurance policies. Item 18, if you want the other party to address any physical or emotional condition that may limit their ability to work and what they base that on, mark box 18. Item 19, if you want the other side to address if they have any children with special needs, you would mark this box. And then line 20, if attorney fees are at issue and you want to request the other party to disclose the total amount of attorney fees and costs incurred by them, how they've been paid, describe the billing arrangements, mark box 20. And then 21, and this, again, probably only pertains to a divorce or legal separation case, but if you want the other party to disclose any gifts they've made without the consent of their spouse or domestic partner in the last 24 months, their values, and the recipients of those gifts, you would mark box 21. The other side would then have to serve this response on you within 30 days of date of service with all the requested documents that they're to provide pursuant to these form interrogatories, and again, their statement under penalty of perjury, attesting to the veracity of the statements made herein. So I hope you found this helpful. Good luck.